Hello, and welcome to In the Privy Council, a weekly podcast reviewing cases heard before the Judicial Committee of His Majesty's Most Honourable Privy Council, brought to you by the Legal Style blog. I'm your host, Elijah Granite. This week, we are discussing the Bahamian case of Responsible Development for Abaco and the Right Honourable Perry Christie and others, the citation for which is 2023 UKPC 2. This case centers on public interest litigation over development on the Bahamian island of Abaco, which the Responsible Development for Abaco, that's RDA, object to. RDA is a non-profit-making limited company, founded by Bahamian residents and funded by donations, with the goal of bringing litigation against what donors view as damaging new development projects. When a proposal was made to build a large marina in part of Abaco, RDA brought a judicial review in 2017, which is why the first-named defendant is the now former Prime Minister of the Bahamas, the Right Honourable Perry Christie. At trial, my lady, Madam Justice Hannah Adderley, required a security for costs against RDA of $150,000 Bahamian dollars, today worth about 122,000 pounds sterling. RDA appealed to the Court of Appeal, where my lord, Justice of Appeal Sir Michael Barnett, made the decision on security for costs afresh, weighing if the security for costs would stifle the public interest litigation which RDA claimed to be conducting. Here, Sir Michael relied in part on the decision in the case of the Crown on the application of We Love Hackney and Hackney London Borough Council 2019 EWHC 1007, admin, where my lady, Mrs. Justice Farby, held that a claimant asserting, as RDA was, that a security for costs would stifle its public interest litigation had the burden of demonstrating that no third parties could reasonably provide the security. Sir Michael's analysis concluded that this security would not stifle the claim. And, further, in light of the intervention in the judicial review of the developers of the proposed marina on Abaco, Sir Michael added additional security to Madam Justice Hannah Adderley's total, with the result that RDA was now stuck with a security for costs of 250,000 Bahamian dollars. RDA then appealed to the board. For the board, my lords, Lord Sales and Lord Hamblin of Kersey, giving a joint judgment, began by considering the constitutional right of access to the court, which arises both from Article 15A, right to protection of law, and Article 28, right to a fair hearing in a reasonable time by an independent and impartial tribunal, of the Bahamian Constitution. This right is subject to reasonable regulation to advance the legitimate aims of protecting the rights of others. For example, the rights of opponent to access the courts is defended by a security for costs given by the claimant. Thus, when a limited company with no assets is incorporated for litigation, like RDA, the rights of the opponents can be protected through a security. And here, the Strasbourg case of Tolstoy-Miloslavsky and United Kingdom, 1995-20 EHRR 442, was cited as persuasive authority. In determining if the restrictions on RDA were proportionate, the board considered, inter alia, the decision of Mrs. Justice Farby in the Hackney case referenced earlier. In that case, the existence of, quote, successful and resourceful backers who have the funds to provide security and to enable the claim to continue, end quote, meant that the claim was not stifled by reasonable security. As RDA conceded in evidence that it could not meet the security by using the resources of its backers, it could not even claim that its claim was being stifled. Thus, RDA had failed entirely to discharge its duty to demonstrate to the court that it did not have the means amongst its backers to meet the security for costs. The absence of evidence meant that the presumption of the security for costs was unmoved. Thus, from a constitutional perspective, RDA had failed to show it had been denied access to the courts. The board then considered the related question of the court's discretion about costs in public interest litigation. Their lordships noted that general public interest litigation can be cause for departing from the usual rule that costs follow the event. That is to say, the state might not be able to recoup the costs of successfully defending a claim for judicial review. Determining what counts as a general public interest claim is a careful exercise determined by balancing the circumstances of each case. In particular, because most cases involve both a private interest and a general public interest. The goal of this discretion is to advance the twin policy goals of ensuring that people are able to bring claims of judicial review and hold public bodies to account, and also that frivolous claims do not impose a burden on public resources. If RDA felt that its public interest bona fides were strong enough, it could have asked Bahamian courts to make a protective costs order under their inherent discretion. See Section 30, subsection 1 of the Bahamian Supreme Court Act. The final issue before the board was the additional security added by Sir Michael to cover the costs of the interveners. The applicable framework here is Bolton Metropolitan District Council and Secretary of State for the Environment. 1995, 1 WLR 1176 HL, where my lord, the Lord Lloyd of Berwick, held that the developer is only entitled to costs where, quote, there is a separate issue on which the developer was entitled to be heard, which was not being covered by the state's counsel. RDA argued that the developers had not shown they were advancing separate issues in the case. Here, the board agreed with RDA because the evidence, despite strong submissions by Mr. Peter Knox, KC, for the developers, failed to demonstrate any additional interest. The issue in the judicial review was largely between RDA and the government. This was especially the case in light of the fact that courts must be cautious in granting additional securities for costs where the defendant is the state. Thus, RDA lost on the main security for costs, but won on the issue of the additional security of costs to cover the costs of the developers. As we turn to our analysis of the case, I suggest that there are two issues which are highlighted by the board's decision. The first is one of practice. Despite the fact that RDA brought to the litigation a team of 6 barristers, 2 KCs and 4 juniors, they failed to demonstrate the basic elements of the claim for a security for costs, and presented no evidence that it was really stifling the public interest claim for them to put up the $150,000 security. This may have been a strategic decision, because it was striking how on the final issue, security for costs for the developers, the arguments of counsel as filtered through their lordships suddenly became much more substantial and involved. This gives some insight into the give and take of appellate practice, where a stronger ground may become the focus of an appeal, while the weaker grounds can be effectively left to wither on the vine. Finally, to a point of theory. The line between public and private interest litigation is a fine and subjective one. As their lordships rightly noted, no litigation is ever truly public or private, and this creates difficulties when we want to give special privileges to litigation in the public interest. This case highlights the difficulty of that balancing act, when it is solely the province of the court to determine departures from the normal rules of costs. The board noted that the situation in England is clearer, thanks to codification via inter alia the Aarhus Convention, and Sections 88 and 89 of the Criminal Justice and Courts Act 2015, there is more clarity. In jurisdictions like the Bahamas, where the court decides without any rules except those set out in case law, the evaluative balance is harder, and ultimately one best left to the trial court. It also means the burden on the claimant becomes all the more important, because there is no statutory yardstick to measure how to depart from the cost rules. It all becomes a question of the claimant finding the right evidence for that case to convince the court to depart from the normal rules. This leaves the question, is the English approach better at balancing the public interest in the Bahamian one, or is it the other way around? I don't know the answer, but it's good food for legal thought. Thank you very much for listening to another episode of In the Privy Council, brought to you by the Legal Style blog. If you want more legal content, visit our website, legalstyle.co.uk, or follow us on Twitter @LegalStyleBlog. If you have any comments, suggestions, rants, or raves, the email of the podcast is editor@legalstyle.co.uk. We also welcome any ratings or reviews on your usual podcast platforms. Until next time, goodbye, and God save the King.